Welcome to Morning Bytes with Stu, Jason, and Violet, broadcasting live on June 5th, which means we're officially in the start of the summer season and just around the corner from Cyber Prom next week in New York City. Morning Bytes is the show on LinkedIn Live where we take the biggest cyber privacy, AI, cyber insurance news from the week and try to make sense of them in just 30 minutes. And we also love to bring on special guests. We keep just enough chaos to make it interesting, but a couple of quick ground rules before we get started. These views are our own and not that of the companies that we work with. So please don't hold them against us. This is also recorded and your best comments live forever. So please, we can see it in the chat. If you're going to stir the pot, at least make it clever. So let's get into it. And we've got two guests who don't just show up to the conversations, they tend to shape them. So first up, Ana Maria Lanaverde, who's also nominated for Cyber Insurance Person of the Year for the Americas next week. And we can't wait to see the results. It's a reflection of someone who's been actively building in this industry and making it into something that matters. She's at the center of the biggest conversations in cyber insurance, but she still takes time to break down the details for little people like us. And remember my sticker that I made one time that says, "Don't ask me about the war exclusion"? She may have had a thing or two to do with that over at Munich Re. She's formerly from Euclid Cyber, and we can't wait to see what's brewing in her next role. And if she's lucky, she's going to drop a take or two today that'll make at least one carrier or underwriter in the audience rethink their entire underwriting strategy. And then we have David Sauce. David Sauce is from Troutman Pepper Locke. And while most of the industry is still trying to figure out what is going on with AI regulations, he's already 3 steps ahead, turning it into a legal analysis. He has become a go-to for everyone in the emerging groups of emerging tech law and real world impact. You might have seen him on podcasts with IAPP and other privacy groups, but we're so thankful to have him here at Morning Bytes. And just fair warning, if we get Jason, Ana Maria, and David talking about AI, Stu and I might not have much time this time, so I took the intro. But we're going to kick off with news. Ana Maria, we'd love to hear from you. What do you think what is on your mind in terms of news this week? At the start of the summer, what do you have?
Well, thanks for that intro. That was great. That was lovely. Thank you. So much going on in the cyber world, as always. I mean, it is the cyber world. But one of the things that I've been paying attention to is all the news around AI chatbots and how they play a role. You know, we talk about Grok, we talk about ChatGPT, and how in the news we see them playing a role in instances around self-harm and gun violence and addiction risk. And so these really serious matters, right? But just this past Tuesday, there was an article, and actually there were a lot of articles, but I honed in on the Tech Times. Their article went a little bit deeper, and this is the one I picked up. It was called "Florida OpenAI Lawsuit Names Sam Altman Personally in the First State Case Against ChatGPT." It's an 83-page civil complaint, but it is also paired with a criminal probe over the 2025 FSU shooting. And Florida is seeking billions in damages. So really attention grabbing, right? So I dove into it. And what was really interesting in this particular article was the specific harms that they mention. And I'm just going to read a few to you and then kind of tie it together with some real life examples. So some of the alleged harms are: OpenAI marketed ChatGPT as safe while concealing documented internal safety concerns. OpenAI suppressed internal warnings from researchers, disregarding expert criticism and prioritizing profits over user protection. And the third one, ChatGPT helped mass shooters plan attacks, encourage vulnerable users to commit suicide, addicted minors to a tool, and cause cognitive harm. All of these allegations are not familiar to us in the cyber world, right? Because we have bodily injury, property damage, all of these exclusions that we think, product liability, that we think will save us. But when you think about those specific allegations, what they all ring to me is allegations that we've heard about in major opioid litigation, right? So the addiction factor, the causing harm to oneself, parental consent out of the loop, and in particular, suppressing warnings that these tech companies are getting. They know that there's risk to children and people, but they're prioritizing profits. And it all sounds oh so familiar when we think about the opioid litigation. And so my question to all of you, I'm going to stop there and just ask you is when it comes time for these policies to get tested in the courts, is this the cyber Armageddon? Is there going to be some way that cyber policies get pulled into this, or could this be a broader market impact and we could see these types of allegations triggering multiple policies like tech E&O in addition to CGL and products liability? That's a big.
You just jumped into the deep end of insurance too, though, and you said cyber world, but I wanted to be like asterisk cyber insurance world, because I would also ask. I mean, I would also throw in another question: is there's so many acronyms, and right now the BI that I have been focused on is business interruption, but you're talking about bodily injury, so we're having this other piece that's almost even compounding a lot of the things that brokers are currently pushing in, which is just property damage, right? We're just
and for those people who think bodily injury is, we have a firm exclusion in cyber and in tech E&O policies. Don't forget, we have personal injury coverage and we have contingent BIPD.
And in this market, these are things that brokers are pushing back on, right? In this market, these are things we're trying to get covered. So even if it's something you think you're excluding right now, is it something you're going to be able to continue to exclude is a question.
Exactly.
Well, I'd add one more piece of the puzzle. I'm a little bit outside the cyber world, as you guys know, my privacy AI, field tracking and compliance, but there's been several states, Washington, Oregon, and California, that have enacted laws directed at companion chatbots. There's been more than those 3 states. It's also Georgia, a few other states. But the reason I highlight those 3 states is because they all have private rights of action. And in particular with Oregon, there's private right of action with statutory damages. And so when you look at these sort of like these lawsuits that are being filed by the Attorney General's offices, that's certainly one risk profile. But if the advancement of chat features, and we've written a lot about this, about how chat features are getting more sophisticated. They, even just retail chat features, they remember people in between sessions. They will ask you unprompted questions. They will solicit emotional responses, those types of things, even just engaging in normal retail, financial services, buying clothes, all those types of things, because it's getting more and more advanced. And as that starts getting it more and more, one of these things where like we've written a law this year and what it's going to look like in 2 years from now, and there's statutory damages associated with it. You're talking about like class action lawsuits. And I don't know, in your guys' world, that's the question of like how you're going to handle those. But we've been jumping up and down saying like, beware of Oregon. It might be the next SIPA, right? With all the litigation that's happening around SIPA. So I think it's fascinating.
David, you want to tell the audience what you mean by it might be the next SIPA?
Oh, yeah, sure. Sorry. I feel like with privacy law, we have to talk in a lot of acronyms. Apparently, cyber world too, you guys, insurance world, they got the acronyms. So SIPA, the California Invasion of Privacy Act. So those would be like those ambulance chasing, lawsuits that you get that, everybody's looking for a quick score. Some of them are getting bigger now. I don't mean to minimize that in any respect, but it's the, I feel like the letters are ubiquitous. We all know the firms who are sending them out there. So it's one of those things where, if you're looking for a quick score, you can get one. And I kind of look at these these companion chat feature laws, which are very, very much directed at, AI acting as your boyfriend, your girlfriend, your best friend, those types of things, mental health type things. They're very, very much directed at that, but they wrote them so broadly that, at least my interpretation is, a plaintiff's lawyer could at least make an argument that it satisfies it enough to extort a settlement demand out of you.
What were the other 2 states you said had private rights of action besides Oregon?
Washington. So Washington's chat feature does. It is the same structure as My Health, My Data. So you may recall that we all thought we were going to have the apocalypse of My Health, My Data lawsuits that never came to pass. There's a case in Washington called Hangman, which is what we think is preventing a bunch of those lawsuits from happening. And then California also has, my recollection is California has PRA, but no statutory damages. I might be getting that mixed up with New York's New York's law, but either way, I think it's California. But if not, it's New York. Don't quote me on it. It's not being recorded, right?
No one's here to call you on it. Yeah, we don't have the alternative facts.
The chat is going to fill up with all the ways I'm wrong. Everything is just going to be like
I think we'll have to add a new instruction in the beginning, Violet, that says no attorney-client relationships have been formed by you listening to the show.
Yeah,
I thought that's covered by we're not representing our organizations.
I think it's fascinating for me jumping in here because, this is not really my world with the insurance stuff, but I can absolutely unequivocally see how it's the leading edge of what you guys are going to be dealing with in just a little bit, I imagine. So
I think it's fascinating too, because I came into cyber through privacy, through looking at it, David, from your side, seeing how the preventative, what you needed to do to comply with the laws, and now realizing now that I'm on the insurance side, you have to almost look so much further ahead because you're trying to see what is the economic harm that's going to be happening that we need to foresee, that we need to either affirmatively cover or affirmatively deny, or are we going to have loosey-goosey language? And that's actually where the word silent cyber came from, through people trying to go through property general liability policies and say, well, surely this is covered. And then the court saying, well, if you don't exclude it, I think it includes it.
And remember, it's not just economic harm, right? We also have mental anguish, emotional distress, all of those, personal injury exposures. Policies have a duty to defend. So even if it's defense costs, these could be costly claims to defend.
So because I'm trying to figure out what the scope of impact could be here, because a lot of this seems like it is going to be confined to the frontier labs, right? So we have a handful of companies there, but we mentioned retail chatbots and things like that. Does it start to extend beyond the frontier labs? I'm trying to understand how that starts to trickle out from kind of the core of it.
Yeah, maybe I jump in on this one. So what Anna Marie was talking about with respect to the lawsuit that the Florida AG's absolutely frontier model type situations, they are the ones we all know about: ChatGPT, Claude, those types of things. They make safety representations. We're gonna, we care about your safety, all those types of things. They're the focus of federal level type stuff. I was going to preview that a little bit, but then so that's the developer angle, right? And then when they go to market and they talk to consumers, that's the deployer angle. And the law is breaking it down into those two roles right now. Very much what we're seeing. So we're seeing a few laws pass, like the New York, California, and Illinois have frontier model laws, and those are directed at the ChatGPTs, the Anthropics of the world. You cannot, don't give guns to the AI. It's kind of the idea behind those ones. Let's not have Terminator, right? And then the other one would be looking at how companies actually are using AI interacting with consumers. So we'd have chat feature laws, which have a bunch of those, and those are things like you can't harm consumers, all the things we were just talking about. You'd have employment is a huge piece of the puzzle right now. So you'd have how AI is being used in employment. If you've applied for a job recently, or someone who has, you get these situations where it's going into the AI, it's filtered, it's searched, you get scores and those types of things. So you're never even getting a human through the search through the feature. So that's being regulated, and notices and opt-out rights and those types of things. So yeah, it's use case dependent. There's in healthcare, it's talking about can you use mental health chatbots? Can you transcribe your recordings with people, with patients? Can you use AI to determine who gets services, who doesn't get services, prior authorization stuff? So these are my weekends, Jason. This is how I spend my nights and weekends. Is looking at all these bills.
So thrilling.
I'm looking for what's the next metapixel issue that starts to pop up here, and is that a
you
fair
cannot
parallel?
Go on the plaintiff side. I've already told you that, Jason. You are not allowed to go to the bad side.
You have to go to the bad side so you know how to defend against it. What are you talking about?
Well, I mean,
Jason, if you're trying to predict the future for plaintiffs' bar behavior, I always say a formula, and I think one of what David's thoughts are, since he sort of sparked the idea in his earlier comments, is whenever you have a statute that has both a statutory damages provision and a private right of action, it's an invitation to the plaintiff's bar to figure out a way to weaponize that in a mass scale.
So why
And
do the legislative bodies still push those out?
Why
I'm not going to.
why did
I have no
Oregon attach
observations on that question.
why did Oregon attach statutory damages to it and push it out?
Well, yeah, if that is, because I would 100% agree with Stu, is that feels like a blinking light. So why do you have like
Well,
legislative bodies that do that?
well, and with the tech lobby support on the bill, right? And so I think what it ended up being was the language in the bill. You could read it. I mean, somebody could read it and say it's really only directed at companion chatbots, boyfriend, girlfriend, best friend type applications. But I think the language is ambiguous, right? Because like there's exceptions there, and it says something like, well, solely used for commercial purposes or something like that. You start thinking about it, you start thinking, well, if this chat feature remembers you in between sessions and elicits emotional responses and
It's
has unprompted thing, it's not solely, right? Like it's not solely. And so like you see later in the year, you see like Colorado's chat bot law, I think it was signed, that doesn't have the same type of language, like that solely type language. It changes it, right? So I think it's one of these things where there's so many bills that are floating around, and Oregon's session was so short this year. And so like things just aren't getting caught, and maybe they get caught later. But to Stu's point, Stu hit the nail right on the head, right? Which is like prior right of action and statutory damages, right? And it's BIPA and it's SIPA. It's all over again.
Right.
So the only thing I would say is somebody said prediction. The only other thing I would add to it is since I grew up in the Philadelphia area, whenever somebody asks me for a prediction, I often think of Rocky 3, where Mr. T played Clubber Lang in it, and he asked him what the prediction for the fight would be, and he said prediction, pain, right? And so that's exactly what I think we're in for. And this whole thing is just like pain. We're just tons more, nonstop bills, nonstop laws, all those types of things. So.
And before we switch to the next topic, for the non-lawyer here, what is private right to action?
You get sued. Sorry, Stu. Go ahead. Sorry.
Yeah, it means that an individual can file a civil lawsuit for damages as a plaintiff.
Oh,
as opposed to like an attorney's general.
Correct.
Got it. Okay, cool. Thank you.
And just to,
please,
yeah, and I was just saying, regardless of the right of action, I would also say that if you look at what we've seen with respect to nuclear verdicts, that sometimes case law doesn't necessarily determine the size of these settlements, especially when it involves children and when there's, when it becomes a much bigger issue than just that one case, right? And these are like socially, they're just huge social topics, and I could see settlements being extreme in these cases. And when we just to point back to opioids for 1 second, we saw everyone, regardless of the services that they provide or the role that they played. So distributors, pharmacies, manufacturers, and consultants, thinking about, Frontier, we have developers, we have, who is the arm behind the chatbot. So we're going to see auditors and consultants, and we'll see other parties brought into these cases.
I would just take some caution before we move on to the next topic. Also on that topic, Anna Maria, when we have a lot of that, you point to the reason those big cases send out social messages or they correct sort of behavior is because there is a punitive element to it. It is not just a measure of compensatory damages. And so in a lot of ways, the insurance industry is immune from those sort of larger lessons learned because there's generally no insurance available for intentional acts and those sort of fraudulent acts that are a lot of times at the core of some of those social issues like the opioid issue and even maybe some of the new hot, emerging technology issues that we're dealing with from an ethics perspective. I'd agree. So, but these are really interesting topics. It does also raise, what role should the government have to protect its citizens from that type of risk? And every citizen's different. There are very sophisticated actors or users, I should say, that would take quite exception with anyone restricting their use of the availability of artificial intelligence. And so maybe it's a sliding scale. Maybe it's, the more you pay for your license or the different technology that you use, the more liberty you have to use the technology. But as you started with, these are really, really challenging issues.
Yeah.
David, what story you've been paying attention to?
Yeah, it's more AI. I think this is the AI session for you guys. So the story I ripped from the headlines was yesterday's Politico story about a new federal AI discussion draft being released. It is a short 289 pages long, and Politico refers to it as the quote last really realistic chance to craft federal rules governing technology before the midterm elections. I thought that was kind of like an interesting way of phrasing it because it was in the same week as we actually had a hearing on a privacy bill. The AI one was saying the last realistic chance to craft rules for technology. It covers a bunch of different topics, but the one I wanted to focus on is actually it's just relevant to the topic we're talking about was the frontier model topic. So again, we're talking about the Anthropics of the world, the ChatGPTs, OpenAI, those types of things, right? Those large, database we read about all in the news. And it would be based upon the California and New York laws that passed, the frontier model laws that passed, and Illinois just passed one as well. Designed it like making sure there's catastrophic risk protections, third-party audits, those types of things. The thing that I kind of thought was interesting, though, was it would preempt state laws, and this goes to Jason's question, so it's good foreshadowing. It would preempt state laws, but only with respect to developers. So state laws directed at developers like frontier models. It would not preempt state laws directed at deployers. So all the companies that are out there would still have their AI open to regulation. I would say it was a big grain of salt. Do I think it's going to pass? No, I don't think there's a snowball chance in this thing passing. I think it's a discussion draft. Why do I think it's interesting? Well, just a year ago, we were talking about a 10-year moratorium on states passing AI laws. And now we're talking about this one would sunset in 3 years. So we're talking about only a proposed bill that would regulate only developers, not deployers, and it would only be a 3-year sunset on it. So the conversation is changing, and I think that that's kind of indicative of this entire area of law and this entire area of AI as well. Is if you don't like the current wind, just wait a minute and it'll change. It's kind of like I'm in Denver. If you don't like the weather in Colorado, just give it a half an hour and you'll like it. It'll change. A lot of this has to do with the Trump administration, their approach on AI, which is itself seems to change by the minute, depending upon, I think, Violet, you had something that you came out with recently on an executive order about exactly that. And so I think
it says nothing, right? It says in the executive order, it says nothing.
That's nothing. And then, this week there was, you can voluntarily submit your frontier model for checks and those types of things. So I think the takeaway is I've made my reputation tracking state legislation and being a state expert. And I think, I think I'm fine. I don't think we're going to get preempted anytime soon. And I think we'll continue to see this incredibly strange way in which state AI laws are developing. And it's much, much different than the privacy landscape where we had a couple of dominant models. We have chaos out there and the terminology is not the same and the concepts are not the same. And so it's getting, in my world, it's getting very, very tough to be able to advise clients in a way that is like a common sense approach to everything.
Hey, let me ask you some follow-up on that, David. I think there's some analogies here to just general, I would say corporate acceptance or corporate adoption of AI in any sort of realistic way. There have been a lot of studies recently that have come out that said even though the business itself is quick to choose a tool and buy licenses, that the actual usage of the AI varies widely between different kinds of enterprises. On the one hand, you had where the very large tech companies were overusing tokens and spending unsustainable amounts of money on token usage, and whereas we have other, especially in the professional services, which you and I both work in, where in fact there's not a lot of usage at all. The take rate is actually very low amongst professional services, even though the benefits are sort of so clear, at least from the marketing. A lot of times, one of the things I wrote about this a couple weeks ago, but it's relevant here, which is the people who are doing the buying decisions a lot of time are not the people who understand, so fluidly the technology itself or the usage, the best way for an enterprise to use the technology. And then when you take it to a policy level where you're now talking to politicians and elected officials or regulators that are themselves perhaps limited in their experiences, you have this weird sort of conversation happening, which I think maybe is the reason why there's so much fluidity on the policies, is because it's really hard to explain some of these things, and the technology does change very quickly. I know that with the use of, for as a law firm, the way we use AI internally has changed within the last 6 months alone. I mean, I can't imagine what it's going to look like a year from now. So I think there is some just uncertainty out in the world about this technology in general, and to extrapolate that into these real life decision making on business buying and usage and policy making is just adding to all of this.
Yeah.
Okay, David, I want to see if you remember this IAPP sticker. It says mythical creatures, U.S. privacy law. It's a 10-year-old sticker, and I think they just need to update it to U.S. AI policy.
Yeah, I think folks remember Keir Lamont, who used to run the Patchwork Dispatch, and he said, like, you never got rich betting on the Congress to pass a federal privacy law, right? And so, like, we just changed that to AI.
Exactly.
I do remember that sticker. I think I have a few of those somewhere back here. But I mean, still, respect to your question, it was sort of like, well, my gosh, what do we have, like 5 minutes left? Because I could talk for an hour on those things,
Right. Yeah,
right?
yeah.
And I mean, we help, in my practice, we help clients analyze the AI risks all day, every day. That's a lot of what we do now. The practice is very much taking that on. So, like, you have a client who's, taking X AI feature and they're going to deploy it, and they say, like, okay, what are the risks of doing these types of things? And we had to look at the patchwork of laws, but responsible AI principles, transparency, contractual provisions. Can it train on your data? Can it not train on your data? All these types of things that are just, and it's, but I think to your original point, though, there is an adoption issue. I mean, I would encourage anyone who hasn't spent time looking at AI products to make their life easier, like, you're missing the boat. I mean, you got to get out there and take a look at these products. I mean, I do a lot of webinars, right? And, I used to sit down and write webinar decks on a Saturday morning at 5 a.m. and start writing, and 10 hours later be done. And now I can take an article and put it into an LLM, specifically design one, and it pumps out a fast. And yeah, I still work on it for hours, but, like, man alive, that is a heck of a tool, right? And so there's tons of those. Claude is, it's just come out with its new model. It's just fantastic for legal. It just really is. So it's really interesting. I think, like, especially with lawyers, like, if you're not adopting AI, you're just not, you're not leveraged. You should be. You should be thinking a lot about it. So
I think we need to stretch that to insurance. Don't you think, Anna Maria?
I mean, absolutely. I look at underwriting and how much of underwriting can be done by AI. Quite a bit of it.
Or even
and
just bring in the word automation.
Yeah.
Oh, yeah.
And
correct some of the inefficiencies.
And I would only just kind of make the connection, right? Like, state lawmakers, I've worked with them for years on trying to craft bills. They read the headlines, right? And so when they're reading things about, like, kids interacting with chat features and then committing mass shootings, right? That's the Florida. I mean, that's what Florida comes out of, right? Or committing suicide and those types of things. Like, they go back to the state house and they start running legislation on those issues. And so as more adoption takes place, to your point, Stu, like, as more adoption takes place and more companies deploy these things, like, there's just going to be more. There's just going to be more and more regulation and more stuff. And so it's kind of, I think we're on the start of a 10-year cycle, much less than we are at the end of a 5-year cycle.
So, David, quick question. Do you see any of this regulation actually creating standards for these companies? I just feel like I don't see any standard setting at this point, and that's, to me, something that I'm looking for.
So, like, in, like, a lawsuit type thing, like, you could point to something and say,
no, I mean, like, setting standards for the AI developers to say, like, this is what you need to be thinking about as you develop this product, and have end user protection in mind when they're doing those.
We tried it. Yeah, we tried it. We tried it in Colorado, and it was SB 205, the Colorado AI Act, duty of care for developers and deployers when deploying high-risk AI systems. It did not survive. It got repealed and replaced with SB 189, which is the disclosure bill. So, like, that's been, to your point, I mean, like, that's been the line that people have not wanted. The frontier model ones, the New York, California, and Illinois, are designed to sort of say, like, hey, like, you've got to you've got to have something built in there, right? But this idea of like responsible AI as a standard, a state law standard, there's been such pushback from the tech community on that one that it just hasn't. I mean, like I said, Colorado passed it, at least as I understand your question, and the blowback was immediate and it was fierce and it was fatal to the eventual bill.
All right, so you want to close us out?
Yes, well, thank you everyone who joined us today. We really appreciate you spending part of your day, part of your month with us here on Morning Bytes. A big thank you to our guests, David Staus and Anna Maria Landaverdi, for taking time to share your insights and perspectives on this awesome show. This was a great conversation. Thank you guys so much. Please, if you're not already doing so, follow David and Anna Maria on LinkedIn. Follow Violet, Jason, and myself on LinkedIn. We will be back next month in our Independence Day special, featuring very special guests, Jennifer Birnbaum and Brian Robb. That's also going to be an awesome conversation. So until then, stay awesome, and we'll see you next month.
Bye.